You know, we're all told that in the workplace, discrimination is illegal, period. But what if I told you the law itself has this built-in exception, a really controversial defense that lets an employer hire someone or not hire them specifically because of their gender, their religion, or even their age? Yeah, that's what we're digging into today.
Okay, so this right here, this is the bedrock principle of modern American employment law. It's the whole idea that your skills are what count, not who you are or where you come from. This is the default setting, the rule that everything else is measured against. Aha, but this is where it all gets a little weird. It raises this fascinating question. What happens when a characteristic like your gender isn't just a preference, but is supposedly absolutely essential to do the job? This is the heart of the legal puzzle we're going to try and solve.
So here's our game plan. We'll start with the big rule against discrimination. Then we'll get into this rare exception, the BFOQ. We'll look at a major case study involving sex, explore some other wild justifications, and then, this is the big one, we'll reveal the one line the law absolutely will not cross, and why any of this matters to you.
All right, first things first. Where does this rule even come from? Well, the main pillar is Title VII of the landmark Civil Rights Act of 1964. I mean, this is the piece of legislation that completely transformed the American workplace. The law is super specific. It lists these 5 categories as protected classes. That means an employer just can't use them as a reason for hiring, firing, or promoting. It's like a legal shield for workers, creating that baseline of fairness we all expect. Now, keep that in mind, because this exception we're about to get into, it really puts that idea to the test. So, if that's the rule, what's the exception? It's a legal defense called the Bona Fide Occupational Qualification, or, BFOQ for short. Now, don't think of this as some kind of giant loophole. It's more like a tiny, heavily scrutinized legal keyhole. And the words you really got to remember here are rare and narrow.
Okay, let's break down that legalese. Bona fide is just Latin for in good faith. The qualification has to be genuine and reasonably necessary to the normal operation of the business. This isn't about what's convenient or what customers might like. No. It has to be essential to the actual core of what the business does. The bar for proving this is incredibly high.
This really lays it all out, doesn't it? On the left, for things like sex, religion, and age, the door is, it's cracked open a tiny bit. It's possible to make a BFOQ claim. But on the right, for race and color, that door is slammed shut, padlocked, and barricaded. The law says that's a permanent no. We'll get to exactly why in just a minute. And hey, don't just take my word for how rare this is. The Supreme Court itself said, way back in 1977, that this exception has to be interpreted as narrowly as humanly possible. The default is always, always, always non-discrimination. So, what does this actually look like in the real world? Let's dive into the most common and definitely the most controversial category for these BFOQ claims, sex. This is where you see some really wild arguments pop up in court. Okay, check out this classic side-by-side. Back in the 70s, Pan Am Airlines actually tried to argue that being a woman was a BFOQ for a flight attendant because customers preferred it. The court shot that down. They said, look, the essence of an airline is safe travel from A to B, not customer comfort. But then you look at the TSA needing female agents to search female passengers. That was upheld. Why? Because the core of that job gets into issues of privacy and safety, making gender reasonably necessary. See the difference? And sometimes this stuff gets really complicated. Take Hooters. They argued their entire business model is based on the Hooters girl, that sex appeal is the product. Now, that case was settled out of court. It was never decided, which is why the practice continues. Compare that to a hospital, where a court agreed that a patient's right to privacy in an OBGYN ward could justify only hiring female nurses. The focus shifts completely from customer preference to a person's fundamental dignity. So it's not just about sex and privacy. Let's look at a few other areas where this defense can actually pop up and be considered valid by the courts. This breaks it down really well. First up, authenticity. Think of Disney hiring people from specific countries for its Epcot World Showcase. That's allowed to create an authentic experience. Then there's public safety, like the mandatory retirement age for airline pilots. And then you get this really unique case involving religion, where a company could require pilots to be Muslim to fly into Mecca, since non-Muslims face the death penalty there. That's a clear safety and religious doctrine issue. So we've seen where the law is willing to bend, just a little. But now, we have to talk about where it absolutely refuses to break. There is one area where this exception is completely,
Totally 100% off limits.
And this is it, the unbreakable rule. Race and color can never, ever be a BFOQ. And it makes perfect sense if you think about it. When Congress passed the Civil Rights Act in 1964, it was a direct attack on systemic racial discrimination. They made a very deliberate choice to say there are zero exceptions here. They decided that a person's race is never, ever relevant to their ability to do a job. This is the absolute line in the sand.
So why did we just go through all of that? Well, because understanding the extreme limits of this BFOQ thing really helps clarify our rights and also our responsibilities in the workplace. Let's boil this all down to the key takeaways. So for any employer out there even thinking about using this defense, listen up. The legal mountain you have to climb is huge. You can't just say it's more convenient or better for business. You have to prove with cold, hard facts that discriminating is an absolute necessity for safety, privacy, or authenticity. You have to show that without it, your whole business operation would basically fall apart. Stereotypes and what customers might like, that will get you nowhere.
And that really brings us to this final big question, doesn't it? The BFOQ exists right at this messy intersection between what a business says it needs to operate and a person's fundamental right to be judged on their own merits. And as our world and our workplaces keep changing, the debate over where exactly to draw that line, well, that's a conversation that's far from over.